All right, who do we have first on the afternoon docket?
Ms. Thompson is ready with Matthew Estrada.
CR 240, State versus Matthew Estrada. And I show that we're set for motion to revoke today. Are we having a contested hearing?
No, Your Honor, we actually have an agreement on this case. Mr. Estrada's violations were money related and then failure to report after he was behind on money. Mr. Estrada has paid up everything he's behind on in full. So we have an agreement to reinstate his probation, eating up all of his back time as a condition. And Ms. Thompson has the paperwork there to tell us how many days that is. I don't recall off the top of my head.
It's up to 2024. Oh, the days, I'm sorry, it was been how many days? 92 days? Approximately 92 days, you know.
So this is going to be a withdraw and amend, or is this going to be a plea true and continue?
Your Honor, we have a motion to withdraw and amend.
Okay, and she has the paperwork?
Yes.
The only paperwork that I've gotten is the motions to withdraw the motion to revoke. That's the only paperwork that I've gotten.
Is probation out there?
Yes, we do have
It'll
that.
come back to be signed by the judge.
Okay, and is Mr. Estrada, has he signed the extension?
He's he signed the
Sorry, the modification. I'm sorry.
Yes, he did.
Okay. All right, and so he's being amended to do 92 days in jail as a condition of community supervision, and also to include Ms. Thompson's indigent fees. Is that correct, Ms. Thompson?
Yes, Your Honor.
Okay. All right, Mr. Estrada, are we going to do better on probation this second chance that you're getting from the state?
Yes, Your Honor.
What happens the next time you come back?
Prison.
Okay, well, you hesitated. Don't hesitate. You know.
I was gonna say there will be a next time.
Well, there'll be a next time, but it won't be as good as this one. You understand?
Well, yes, sir.
All right, you better take it serious because I take it very serious. All right. All right, state will grant the court will grant the state's motion to withdraw and amend the conditions of community supervision for Mr. Estrada to include 92 days in jail as a condition of community supervision. And the court will amend to include the addition of the new indigent attorney fees from Ms. Thompson and any other agreement that the state and defense have reached.
Your Honor, Your Honor, I'm going to have to make a correction. They looked it up. He actually has 102 days in jail.
All right, so the court will amend to reflect 102 days credit or 102 days in jail as a condition of community supervision, and we'll give Mr. Estrada 102 days credit towards that, meaning that he has served his 102 days and will not get credit for it if he is revoked in the future.
You can understand that. He does understand, Your Honor.
Okay. All right. If there's nothing further, then we'll be adjourned and I'll sign that paperwork when it's brought back before the court.
Yes, thank you, Your Honor. May I be excused?
Yes, thank you, Ms. Thompson.
You're welcome.
Okay, Your Honor, we're ready with Donald Ellis and Ms. Beasley.
CR 19305, Donald Brian Ellis. All right, so let's begin by addressing the state's motion for continuance that was filed in regard to the evidentiary hearing that was scheduled today. Go ahead, Ms. Heisel, if you'll give me an announcement on the motion to continue.
Yes, Your Honor. We were not prepared to move forward with a hearing today. However, some things have happened since our last setting that I believe resolves our need for a hearing. So we would withdraw our motion for continuance at this time.
Okay. With regards to the defense's motion to quash the indictment, is there an announcement from the state on that?
Yes, Your Honor. Last Friday, I presented a new indictment to the Van Zandt County Grand Jury, which was returned. In this cause, we believe that that cures any defect that would prohibit us from moving forward, and we believe that it also cures the defense need for a motion.
Ms. Beasley, would you like to respond?
Yes, Your Honor, I would ask the court to rule in the defense favor on our motion to quash. Despite the second amendment indictment, my argument is my client's been in jail for 2 years or almost 2 years. And this is not the first time that the DA filed an improper indictment. This actually is the second one, and I ask the court to bar the state from proceeding on the second amended indictment.
And this was represented to the grand jury. Did it result in a new charge, a new case number, or just an amendment to the current indictment?
That's correct, Your Honor. Just an amendment to the current indictment. It's still under the same cause number.
I'm taking a moment to review the amended indictment. All right, the court has reviewed the defense motion to quash the indictment in cause number CR 19305. Court finds that the defendant's motion has merit in that it does not, the indictment does not contain an essential element of the offense. Specifically, the state did not allege that the defendant committed an act without the consent of the alleged victim or complainant. However, the court will find that the state has represented the case to the Van Zandt County Grand Jury, and that the Van Zandt County Grand Jury has issued an amended indictment that does contain the essential element without the consent of the complainant in the language in the primary paragraph of the indictment. Based on that evidence, the court will deny the defendant's motion to quash indictment in this case. Ms. Beasley, I believe that at the last announcement, you were working with defense experts. Is there any update? Nothing to disclose work, product, or privilege, but any update on whether we're ready to set this case for a docket caller trial based on your working with the experts that have been retained through court appointment?
Judge, I believe I need one additional setting to get a little bit more information for my client, but we should be shortly ready to go on the docket, for docket call.
I'm pretty full for August. Are you available on September 14th or 16th?
I believe the court set me earlier this week. I can't remember exactly which of those days. If you have a moment, Judge. The 16th, I believe, Judge.
16th. All right, then let's set Mr. Ellis then at 1:30 on September 16th for docket call.
Judge, my client refuses to sign the reset sheet, so I'll turn it in without his signature.
Yes, ma'am. Thank you. I appreciate you noting that for the record.
Have excuse, Your Honor?
Yes, ma'am. Thank you, Ms. Beasley.
Thank you.
Good afternoon, Your Honor.
Good afternoon, Deputy McLeish.
So I see we have one attorney that's coming in a little late, Mr. Manning, and then Mr. Schmidt is working on his signatures right now. So
I believe Mr. Manning will be here around 3, as we're going to be zooming from Henderson County due to their COVID quarantine.
Judge, Mr. Manning also has Schoenfield, which should be a plea this afternoon as well. Are we taking that up at 3 as well?
I'm going to head up as soon as Mr. Manning gets here. So if he's not here till 3, then it'll be 3.
Yes, Judge.
Are we ready to go on Mr. Templin? All right, Mr. Templin, if you'll raise your right hand, I'm going to place you under oath. Mr. Templin, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Make sure you speak up loudly and clearly for me, please. Mr. Templin, your name is Christopher Lee Templin, is that right?
Yes, sir.
And Mr. Templin, you are represented by your attorney, Mr. Brian Schmidt. Are you pleased with his representation of you in this case?
Yes, sir.
You feel like you've had enough time to discuss the case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
And throughout the documents, wherever your signature appears, you're telling me that that is your true and correct signature and that you signed only after reading and understanding the documents.
Yes, sir.
Mr. Schmidt, do you believe Mr. Templin to be competent today?
I apologize. I do, Your Honor.
And does your client waive the formal reading of the state's motion to revoke?
We do, Judge.
And is it his intent to plead true to all counts?
All counts. Yes, sir.
And I see here that the recommendation and agreement is that Mr. Templin's going to plead true to the motion to revoke, and that the recommendation is that his community supervision be revoked, that his punishment be assessed at 3 years confinement in TDC, that he be ordered to pay the balance of his financial obligations, that he receives 43 days credit towards his sentence for the time that he spent in jail on this cause. Is that correct, Mr. Schmidt?
It is, Your Honor.
And that's your understanding and also what you want to do. Is that right, Mr. Templin?
Yes, sir.
All right, Mr. Templin, then I'm going to ask you, how do you plead to all of the counts as alleged in the state's motion to revoke your community supervision? Are those counts true or not true?
True.
And are you pleading true because those counts and allegations contained in those counts are in fact true and for no other reason?
They are true.
And Mr. Templin, has anyone threatened, forced, or pressured you to plead true to any counts today?
No.
All right, the defendant, or the court will accept the defendant's plea of true to each of the counts as alleged in the state's motion to revoke. And there are a total of 15 counts alleged in the motion. Mr. Schmidt, any objection to State's Exhibit A?
No, Your Honor.
All right, State's Exhibit A is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from State,
No, Your Honor.
from the defense?
No, Your Honor.
All right, based on the defendant's plea of truth to each count, court will find that Mr. Templin has violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. Court revokes Mr. Templin's community supervision, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations, which includes a fine in the amount of $2,364 remaining. The court will award Mr. Templin 43 days credit for the time that he has spent in jail on this cause. Mr. Templin, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, Mr. Templin, I'm going to order you to report back to the Van Zandt County Courthouse so you can make arrangements to finish discharging the fine that you owe the county in this case. Your failure to check in and at least get on a payment plan and start trying to work that off will result in a warrant being issued for your arrest. And it's going to be very difficult for you to get a job and support yourself and get re-entered back into society if you're being brought back in on KPS pro fines and things of that nature. So come back to the courthouse, tell them you owe, let's set you up, and then you start making a consistent effort to pay them off, and we'll work with you. We don't want you in jail any more than you want to be in jail, okay?
Yes, sir.
All right, good luck to you, Mr. Templin. I'm gonna have you step over with the deputy to be fingerprinted.
Thank you.
Thanks, Judge. That's all I have. Might be excused.
Yes, sir. Yes, sir. I appreciate it, Mr. Schmidt, and please text me with any updates you get.
I appreciate it. Thanks, Judge. I will.
You bet. You have a good day.
You too.
Hey, Your Honor, we're down to the two that were Mr. Manning's. And he is over in Kaufman County doing 2 pleas. Said he will be here in a little bit. Do you just want us to wait and reconvene at 3 when we do the Zoom with his other client?
What do you mean, as opposed to logging off?
I mean, we're through until Mr. Manning gets here.
Yeah, I guess. Are you requesting something, or you're just saying we're gonna stand in recess till 3?
No, I'm asking you.
You're
Do you
asking.
want us- Do you want us to stand here and wait, or do you want to wait till 3 o'clock?
You want us to stand right here for an hour and 5 minutes and look at each other? Or would you rather us turn the computer off for an hour and go be
This is
productive?
loaded.
I support a thumb wrestling contest.
I got money on Miss Patty.
Thank you.
Aaron
I'm
can
a-
take her.
I'm gonna double down on Deputy McLeish then. Yeah, we'll stand in recess. So yeah, if you'll turn off the camera and mute it, then we'll just wait on Mr. Manning.
Okay.
All right, thank you.
All right, we don't have to wrestle.
Hey, Aaron, can you hear me?
I can. Can you hear me?
Hey, is Jonathan there?
No.
No. Okay, we're double checking.
Yes, ma'am. I promise to let you know as soon as he gets there.
Okay, thank you, ma'am.
They actually have a class in this room at 3 o'clock today, so they're gracious enough to let us finish our stuff first. But
Okay, I just thought
Snatchy.
I'd double check with you real quick.
yes, ma'am. Thank you.
All right.
Hey, Waynette, are you there?
Hey, I am.
Hey, is Judge with you?
He's in his office.
Okay. I've got Lieutenant Harrelson here and Clay from the bonds company.
Yeah.
They've got an inmate in jail who's here from Henderson County, who has an assault family violence charge. And what else, Natalia?
So it was in Henderson, posted on there, came here, and we already had the bond in hand before we found out it was recommended
Okay.
bond and not a set. So if he could see him, I don't know if there's supposed to be an EPO, he's the one that signed the warrant.
Did you hear that?
I couldn't hear her. She's talking too quiet. Sorry.
Come on, girl, talk loud.
Yeah, she's gonna have to talk loud. And
Um,
Patty, I think Patty is listening in too, possibly.
So judge signed this warrant for assault family violence. It's a recommended bond. It's not set. We didn't know that prior to him getting here. Is there any way he can see him to do magistration and if there's an EPO or anything?
While we wait for Jonathan.
I don't know. I just now got in. I don't know what we're talking about.
Oh, come on, Patty. Come on, Patty. You're supposed to know all this. So they've got a guy that's here from Henderson County on assault family violence. He has a recommended bond, not a set bond. And while we wait for Jonathan, Lieutenant is very anxious to see if Judge would be willing to see this guy and check on maybe an EPO or something like that since he signed the warrant.
Yeah, because we have.
What is his name?
What's the name again?
Holland.
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 Yes.
Okay, let me look him up and I'll let y'all know in just a minute.
Thank you. Miss Patty? Waynet?
I'm here.
Very good. Hi, Miss Hillary, we are ready with Mr.
All
Manning.
right. Judge, do you hear that?
Gentlemen, I'm gonna ask while y'all are in here and this is going on, make sure that your phones are muted, please. Thank you.
Give Judge just a second, okay?
Yes, ma'am, thank you.
All right.
All right, good afternoon. This is cause number CR 18421, State versus Brandon Alexander Schoenfeld. Mr. Schoenfeld, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may put your hand down. Make sure you speak up loudly and clearly. Mr. Schoenfeld, are you pleased with Mr. Manning, who is your attorney? Are you pleased with his representation?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir, I do.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Does your true and correct signature appear throughout the documents?
Yes, sir.
Mr. Manning, do you believe Mr. Schoenfeld to be competent today?
He is, Judge.
Does your client waive the formal reading of the state's motion to adjudicate?
He does. We reviewed it in each and every and part of it.
And is it his intention to plead true to all counts?
It is, Judge.
All right, Mr. Schoenfeld, I'm going to ask you, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7 as contained in the state's motion to adjudicate? Are those counts true or not true?
True.
And are you pleading true to those counts because you have committed the conduct alleged in those counts?
Yes, sir.
All right, the court will accept the defendant's plea of true. Mr. Manning, any objection to State's Exhibit A, the defendant's waiver of rights and plea of truth?
No objection.
All right, State's Exhibit A is admitted into evidence and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would ask that you follow the plea agreement.
Anything further from the defense?
Yes, Judge. As part of the plea agreement, my client and his family paid the balance of the probation fees, which totaled as of this morning $21.41. Those have been paid in whole, and he will be paying off the remainder of balance once he exits TDC.
Thank you, Mr. Manning. And thank you, Mr. Schoenfeld. I appreciate that. All right, then based on the evidence before the court will follow the plea agreement that Mr. Schoenfeld has reached with the state. Court finds that Mr. Schoenfeld has violated the terms and conditions of his community supervision. Court will this day adjudicate him, convict him of the third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. Court hereby revokes his community supervision, assesses his punishment at 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of financial obligations that have not been satisfied. Court will award Mr. Schoenfeld 93 days credit towards his sentence for the time that he has spent in jail on this cause.
Judge, if I may, there is a corrected judgment that I believe has been sent to the jail and not to the court. That was the amount of time he spent in Van Zandt County. We also located a number of days in Hunt County that we have confirmed. Mr. Manning does have a corrected judgment. I believe it's in the range of 140. Correct me, Mr. Manning.
I show 135 days.
135?
Yes, that's correct.
All right, then the court will award Mr. Schoenfeld 135 days credit towards his sentence for the time that he has spent in jail on this cause. Court hereby remands him to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Mr. Schoenfeld, I'll have you step to the side with the deputy to be fingerprinted. Good luck to you, sir. Mr. Manning, have you had an opportunity to go over the indictments with Ms. McMillan at all?
If I may, Judge, let me go to my file.
Okay. If not, I have them available on screen.
I know that I spoke to Ms. McMillan on July 1st, and I believe I was able to discuss the indictments with her, but I don't know if I was able to show those to her.
All right, well, I have them ready. We're just, I think Ms. Abraham is checking with Henderson County to see why they haven't zoomed in already.
Yes, Judge.
So we'll just stand in recess and wait for just a moment.
Trash can. They're supposed to do it at 3, but they didn't call in, so. I think she's trying to figure that out right now.
Did you see the judge? Thank you so much.
No problem.
I didn't have these people supposed to be here.
Mr. Manning?
Yes, Judge.
Do you need any time with Ms. McMillan in a breakout room, or are you ready to proceed for arraignment?
Judge, if we can just display the indictments, I think we should be ready to proceed at this point.
All right, can you see the indictment in cause number CR 21226?
I can. Ms. McMillan, can you see the indictment?
Let's see, Ms. McMillan's still muted. If the jail staff is there, can we assist Ms. McMillan in unmuting the device so she can speak?
Okay,
Thank you. All right, Ms. McMillan, can you see and hear Mr. Manning himself?
yes,
Okay, I'm having displayed your indictment in cause number CR 21226. Can you see that on your screen?
yeah, I'm reading it.
Okay, tell me when you're ready for me to scroll down.
You can go ahead and scroll down. Okay. Okay,
Now I'm going to show you the indictment in cause number CR 21227.
okay, I got that one.
You've seen this one?
Yeah, I have that one. The evading arrest one.
Yes, ma'am.
Okay.
All right, go ahead, Mr. Manning.
Ms. McMillan, is your name spelled correctly on both of those indictments?
Yes, sir.
Okay. And you understand that due to the prior felony conviction out of Grayson County, they've enhanced this offense from a third-degree felony to a second-degree felony, with the range of punishment from 2 years to 20 years and up to a $10,000 fine. Do you understand that?
No, I'm not too sure about what it means by enhance, though.
Okay. So
which one did they enhance, may I ask?
they enhanced both of those from third-degree felonies, which is what the original offense would be, to a second-degree felony.
Okay.
Okay.
Did you get any of my letters?
We'll talk about that in just a second.
Okay.
So
okay.
at this time, Judge, her name is spelled correctly. She understands the charge against her, and she's going to be pleading not guilty to both charges.
Okay, court's going to enter Ms. McMillan's plea of not guilty into the record in each cause. Court will set Ms. McMillan for a pretrial hearing on Mr. Manning. Are you available on either September 14th or September 16th?
Let me check, Judge. Yes, Judge, I'm available on the 14th.
Okay, court will set Ms. McMillan then for pretrial hearing on September 14th. Ms. McMillan, if you are still in jail, then the court will convene at 1:30.
On September 14th?
Yes, ma'am. If you make bail in this case and are released, then your hearing will be at 9 a.m. You understand? So
Yes, sir.
if you're free, then it's at 9 a.m. in the morning. If you're locked up, it will be at 1:30.
Okay.
All right. So this will be the only notice. I can't have you sign a form and give you a form right now for you to record. So you need to make sure that you record September 14th at 9 a.m. if you're on bail and 1:30 if you are in jail.
Okay.
Mr. Manning, do you need any time to speak with Ms. McMillan now in a breakout room, or are you going to speak with her at a different time?
Judge, due to Henderson County's situation with COVID, I'll be contacting her via Zoom. I'll set up an appointment next week to contact her and discuss her case in a confidential environment. There are other officers here in the training room, and so we wouldn't be able to speak confidentially. So I'll contact Ms. McMillan and set up an appointment with Henderson County to speak to her via Zoom from the confidential fines in my office.
Yes, sir. Okay. All right, then we'll be adjourned in this case. And Henderson County Jail staff, thank you very much for helping us make this happen today.
So September 14th, right?
Yes, ma'am. September 14th.
And
Go ahead.
and he said sometime, when did he say he was gonna come see me?
I will contact you, Ms. McMillan, via Zoom next week.
Okay, no problem. Thank you.
Thank you.
Thank you. Thank you, Mr. Mullen.
Thank you, guys.
You're very welcome.
Judge, I believe that concludes my business. May I be excused?
Yes, sir. Thank you, Mr. Manning.
Thank you.
All right, I believe that concludes our afternoon docket. Anything else from the state?
Judge, only, was Mr. Dittman's name called?
Not yet. I'll do that. Once I conclude, I will have the name Danny, Mike, Dittman called loudly. Well, let me ask about that. Did the state file a motion for continuance on that case?
We did in fact file a motion for continuance. It was my understanding that we were going to resolve the case, but state did in fact file a motion to continue, which I do believe was granted by the court. So if
All
we
right.
would like to reset it.
Yeah, so Mr. Dittman is going to have until August 26th then, since the court did grant that, because he may have contacted Ms. Taberham or Mr. Schmidt, and we did indicate to counsel that their clients would not have to be here today based on that grant. So we'll give him until August 26th to see if he appears.
I can appreciate that, Judge. Thank you, sir.
Thank you, Mr. White.